I got to take this call, but you'll be very interested in it. Hello, David. You're in jail. What happened? Oh my goodness. Well, we discussed this risk, didn't we? You can't sell securities if they haven't been registered or subject to an exemption. All right, I will rally the troops. It's going to be a long fight. That call was a recreation of a call that I received several years ago from a very successful financial planner who came across a deal of a lifetime. It was an amazing startup that was developing a golf professionally designed course in which he really wanted to invest, but he had a problem. He didn't have the minimum investment needed. It was just more than he could afford. So what did he do? He contacted LegalZoom and formed an LLC. Then he put his life savings into it and did one thing more that was a problem. He went to his financial planning clients and got them to invest their money. So together they had the minimum investment. Unfortunately, the deal turned out to be too good to be true. And to make matters worse, our guy not only lost his life savings, but he was prosecuted for selling unregistered securities. He's now serving a 2-year jail sentence, which was the best deal we could get him on a plea bargain. I love working with startups. I love trying to protect their founders, both from themselves and sometimes from other people. I love writing contracts and trying to help startups make decisions, but there are lots of laws and regulations that must be followed. That's what followed. That's why I told you about my client who went to jail for selling unregistered securities. And if you go to jail, it's a bad legal mistake and it will kill your startup. Criminal liability will make you dead on arrival, no matter how promising you think your venture is. So let's take a look at this more carefully. We're going to go through a series of mistakes, one by one. The first part of this, we'll talk about the criminal mistakes that you need to pay attention to right from the beginning. First one is pretending that you're a securities lawyer, selling securities without an exemption from securities registration. Whoops, there we go. A company cannot offer or sell securities unless the securities have been registered with the Securities and Exchange Commission and with applicable state securities divisions, or there's an applicable exemption for registration. Most common exemption, and some of you may already be familiar with this, is the so-called private placement exemption. That is what most of you are going to be looking at with your startups. It's the cornerstone of startup securities offerings. If you're a securities lawyer and you're doing a startup, you probably already know this and you're probably paying attention. But if you're not, don't pretend you're a securities lawyer. Get help. I've been practicing securities law for 40 years, and I still adjust my advice every year based on new regulations and refinements of case law and so on. You've got to pay attention to this stuff. Criminal prosecution is only part of the risk. You also have to worry about rescission rights. You got to give them back their money. You've got injunctive relief. You've got fines, penalties, and the most important thing of all, never being allowed to do another securities offering. So if you make a mistake here, it's not like you can pay the fines or go to jail and come out and start another company. You're done, okay? Mistake number 2, selling securities to non-accredited investors. The rule of thumb with private placements is to sell the securities only to accredited investors. This SEC has a Regulation D and Rule 506 under the Securities Act that gives us a great roadmap for doing that. 2 reasons to sell only to accredited investors. One, the filings that you make under Reg D are super simple. You just file a form electronically. Secondly, there's no prescribed disclosure document. If you want to sell to other than accredited investors, and we'll get to the definition of that, you have to prepare a very expensively prepared private placement memorandum, and it has to have a lot of things in it that you just want to avoid. Now, even though you may not need a private placement memorandum formally, you still want to make some disclosures to make sure the investors know what they're getting into. And I think it's foolish and it's risky not to provide ample information about the deal, including in the subscription agreement under which the investors invest, a list of the risk factors so that you have something to fall back on. The mistake that some startups make here is to omit some information that they should have told the prospective investors. That comes back to haunt them because it's considered to violate the so-called anti-fraud rules. Okay, who's an accredited investor? People with a net worth of $1 million or annual income of over $200,000 or $300,000 with their spouse. Okay, we have a new definition of accredited investor. This is effective as of August. They've brought more definition to it. People have certain securities licenses, knowledgeable employees of funds, $5 million in assets in an LLC, and so on. This area is constantly changing. As I said, this is a good example of that. Mistake number 3, advertising or generally soliciting for investors. Subject to certain limitations, you can't do this under Reg D, the private placement exemption we're talking about. What does this mean? General advertising is ads, articles, notices, other published or broadcast communication. Whatever you put on a website, if it's not password protected, is considered general solicitation. It's considered general advertising. General solicitation is sending out emails to people. That is, emails to people with whom you do not have what's called a substantial and pre-existing relationship. That is the test for sending emails to people. And the reason for that is because under the law, it's assumed that if you have a substantial pre-existing relationship, you know enough about them to know that the investment is suitable for them. Mistake number 4, using an unregistered finder to sell securities. Entrepreneurs very often make this mistake, paying somebody to raise capital for them. The problem is the finders are required to be registered with the SEC if they're operating as what's called a broker or broker-dealer. Okay? It's a defined term in the Securities Exchange Act, but the definition is super broad. It means any person engaged in the business of effecting transactions in securities. So what does that mean? It covers anybody you pay. So if somebody receives compensation for what they did for you, they're going to be deemed to be a broker, especially if the compensation is based on a percentage of what they raised. Why is this a problem? Several reasons. One, the private placement is blown. Remember the things I talked about before, the criminal liability, never being able to do an offering again? Well, that's what happens. You're done. You're not ever raising money for a startup, any startup again, not just the one you screwed up on, but any startup in the future. Bad situation. And all those other things as well. The investors have a right of rescission, there are penalties and so on. You've got to return the money. And that obligation to return the money is personal. When you accept investment funds into your new corporation or LLC, you personally take on responsibility for complying with the securities laws. And if you don't, and there's a right of rescission, you personally are going to be responsible for for giving back the money. Okay. The next thing I want to talk about is, and the next mistake is violating employment laws. There's a bunch of these that you've got to pay attention to. And we're still talking here about some criminal liability, potentially. If you misclassify an employee as an independent contractor, common mistake startups make. You can be subject to criminal penalties of up to $1,000 per employee. If you fail to pay an employee the minimum wage, I'll make some other comments about that. We have people working on a sweat equity basis. It's a problem. If you hire illegal immigrants, you've got a problem. Make sure you get an I-9 form from all of your employees, just as a routine matter, so you know that you're not violating that law. Let me just give you a couple of items with regard to independent contractor versus employee. If you have control over the person working for you in terms of their hours, they've got to be at their desk, 9 to 5. They have to show up when we get back into offices. They actually have to show up there at a certain time. If they're probably going to be considered an employee and not an independent contractor. Depends on how much control. If you give them an assignment to deliver a result, you don't control how they do it, fine. The minimum wage issue that I mentioned. This doesn't really come up that often. I point it out here because it is a potential problem, and when you have other issues, this one gets thrown onto the stack. Where we as entrepreneurs are not supposed to provide people with sweat equity. Deferring wages, for example, does that work? Theoretically, it doesn't, but people do that as well. I don't advise people as adamantly on this particular issue because we usually just don't have a choice. The illegal immigrants problem, that's definitely criminal liability, so you've got to watch it. Okay. Mistake number 6, violating privacy laws. Pandora, when it went public, received a criminal subpoena regarding its sharing processes. Google executives in Italy were held actually criminally liable for showing a video on YouTube that had an autistic child that was, the video was considered defamatory to the child and to the family. You can't say things about other people in connection with your business that are, have to do with marital infidelity or their criminal activity, or even calling them dishonest. You'll have problems in this area. Mistake number 7, violating tax laws. More criminal liability. The most common violation of the criminal tax laws is the willful failure to pay over payroll taxes that are withheld from employees. The W-2, right? If you collect it, you better pay that over quarterly and don't use it in your business operations. It's a tremendous tendency to do that because the money's sitting there during the quarter until the end of the quarter when you're supposed to pay it over. Don't use the money and hope you get enough additional revenues so that you'll have it at the end of the quarter, because if you don't, you're going to have real problems. I've seen jail time of up to 3 years for this. And of course, the other tax issues that you already know about, not paying income tax or sales taxes. If you collect sales taxes, give them to the IRS, give them to the states, or you're going to have problems. Okay? So when we say avoiding legal mistakes that could kill your startup, the first thing we think about is making sure you know enough to stay out of jail, because that'll kill your startup. The rest of the discussion is going to focus on some other big mistakes that aren't criminal, but they're definitely potentially fatal. And we see them all the time. All right. Mistake number 8. Co-founders getting together too fast without knowing each other very well. Choosing co-founders is probably the most important decision that people make in connection with their ventures. Ideally, co-founders should know each other really well and trust each other. They should be confident of their counterparts, that they should feel like their counterparts will be there when the going gets tough. Sometimes founders make the mistake of going into business with people that they just met. People go to weekend conferences and so on, meet somebody, talk about a startup, and suddenly they're partners. Big problem. Okay. Mistake number 9, forming the wrong entity. The most important advice is to form an entity that will protect you against personal liability. An LLC will do it, of course, but most investors will only invest in a corporation. LLCs are great for lots of things, but if you expect the company to grow and you're looking to raise money in the future, you got to use a corporation. Mistake number 10 is incorporating in the wrong state. The right state is Delaware. That is the state that investors want. Why do they want that? Because they're used to it. They have because they think Delaware has the best laws. And all these other qualities that are on the slide, which are all true. Georgia, for example, has fantastic corporate laws now, and every other state has grown up in their corporate laws, and they're just fine. But investors want Delaware. There are some very interesting things that you can do in Delaware that you cannot do in other states. For example, adopting corporate resolutions by written consent. In Delaware, you can do it with majority consent and let the minority know what you've done. In many other states, it must be unanimous written consent. It's one difference. There's a whole list of things that are different. And as lawyers, we're very used to Delaware law. The courts there are great, and so investors prefer it. Mistake number 11, failing to incorporate early enough. You want to incorporate and issue stock to the founders as soon as possible, before the company has any value. This avoids what we call the cheap stock problem. As the value of the company increases, and the fair market value of its stock increases, selling stock for a nominal price triggers taxable income. So you want to avoid that. If a founder is transferring assets like technology to the company in exchange for stock, IRS Code Section 351 allows the founder to do that on a tax-free exchange basis with some conditions. It's only available at the time of incorporation, and it's not available later as more stock has been issued. Same principle applies to issuing stock options and equity to employees. You do it as soon as possible when the value of the company is low. All right. Mistake number 12, splitting equity equally. Some entrepreneurs make the mistake of giving their co-founders too much equity. We all like the idea of giving everybody an equal share. I mean, who's to say that somebody who does one thing is worth more than someone who does something else? But it's usually not the right business decision. The business was Bob's idea. He's already spent 6 months on it. He's done all kinds of things to get going with it. It's just not appropriate to give Bill an equal share. That is, unless Bill is coming into it later with really something that is pretty significant to put on the table. Splitting equity is a significant decision. You need to take a hard look at the respective roles and contributions to see what's appropriate. There are lots of things to consider here. Who contributed the cash? Who came up with the idea? Who's working part-time? Who's working full-time? Who's going to have the most responsibility, and so on.
Hey,
yes.
Question. It looks like we've got a couple of questions from Stephen Rodriguez in the live chat. Right. If you want to take a look at those.
In the live chat, I'm looking at the site here. I see.
If you'll click on the stage at the top there.
Got it.
Asking any recommendations for par value and share numbers?
Sure. Let's see where we are. Oh, is that at the end here? I hadn't seen this before, but I will certainly answer it.
Yep.
Par value and share numbers. Par value in, if you're forming a corporation in Delaware, should be a very nominal amount, 0.0001 par value. Par value is not used for anything nowadays. It has no relationship to the valuation of the company or the amount that you ask investors to pay for the stock. So it's a very small amount. It is used in Delaware in calculating the annual Delaware franchise tax. And it's there. Delaware has a calculator on its website for doing that. And so what you end up with doing when you're issuing stock under an equity incentive plan to advisors, or you're issuing founders stock at the beginning, it's at this very low valuation, which essentially means you're able to issue stock with for $1 or for $6 or for some nominal consideration. Any other questions before we go on?
It looks like there's a second one from Stephen Rodriguez in there as well. For part-time co-founders, any thoughts on vesting and share value? Want to avoid potential dead weight on the cap table?
Yes, I will. Yeah, I'll address vesting in a minute. We'll get to vesting. All of the founders need to have vesting on their shares. Let me see when that's coming up. Well, that will be coming up soon.
Great.
But why don't I deal with it now? Let's see, where are we in the presentation? We were at.
You're at mistake number 13, not having co-founders' employment documents.
Okay.
And that's totally up to you if you want to hold off on that until
let's hold up on the question on vesting.
Okay.
And I think it's a great one because, yeah, you don't want dead weight on the cap table. Somebody leaves the company, you want to get some of their shares back, or all of them if they leave right away. We'll get to that. I'll get into that.
There's also, Jack, there is a question that just came in on the Delaware filing. Rahul wants to know, is there a good source you recommend reading to compare filing in Delaware versus Georgia for the newest updates?
For the newest updates. Well, there are articles, there are tons of articles that talk about why Delaware is the state. And you Google, Delaware incorporation versus other states or various things. And there's just a ton of articles as to why people form in Delaware. So that's kind of an easy one. As far as the latest and the greatest, every year, these Delaware and Georgia come out with, little tweaks to their corporate laws. They are typically on the edges, and they're taking care of, ambiguities and so on in the law. Typically, not really of any particular importance to startups. So it's you can Google that. I'm not aware of any great articles on the difference in the laws, but I think if you go to the articles about why Delaware versus other states is the best state, you'll see all kinds of stuff that will be applicable in terms of comparing to Georgia. Okay. Anything else at this point, or should we go on?
I think we're good to go. Keep going, Jack. Thanks so much.
All right. Okay, so this mistake, not having co-founders sign employment documents, big potential. Here's a problem for you. Founder leaves, takes his rights to the IP along with him. What does the company do? Well, the company's in a pretty difficult situation at that point because the founder who left potentially owns that IP. And it's even worse if the co-founder starts a competing business. So what do you do about these problems? Well, you have the founders sign agreements. They sign confidentiality and invention and IP assignment agreements. So as part of the consideration for the stock they're receiving, they're assigning to the company the concept and anything that went on before you even founded the company relating to the business concept. And so you know the company actually owns it. They're signing a non-competition agreement that says that if they leave, they're not going to do the same kind of thing for, say, a year after they leave. And you notice I said the same kind of thing as the company, because they may, during the course of the development of your company, come up with another way of doing it that might even be better. Well, they had to bring that into the company and not just quit and start another company. So you need these agreements with founders. The agreements could say that founders work on a at-will basis, so a majority could get rid of them. It's really you have to have agreements. It's the only good way to protect the company's confidential information and ensure that the IP belongs to the company. And by the way, when you start raising money, the lawyers for the potential investors are going to conduct what's called due diligence. And you always have to have this in mind with everything you're doing. They will immediately want to see your corporate documentation. And that means you need to have normal and customary, typical documentation that startups have that have all these agreements in place. And if you don't have a invention and IP assignment agreement, for example, you're done. They don't even, and half the time they don't even tell you why. They just say we're no longer interested. So you take an investor and from loving the business to sending you an email saying we're decided we no longer think there's a good fit. That's what they'll tell you. What they really mean is that their lawyer said there was no invention in IP assignment agreements. All right. By the way, all these slides will be available at the end of the session. I may even have some notes that I can convey to those who are interested, so that you can actually study these things. It pretty much tracks each slide, and I'll provide that to everybody. Okay, let's see where we are here. Why am I not? I want to go to the next slide here.
You may need to click right back into your PowerPoint there, Jack. You may be on a different screen now that you're looking at the live chat.
Oh. Or let's see.
You're on mistake number 13 with the employment documents.
I see that.
You might try taking it out of reading mode and putting it back in, and then going forward with your next slide.
Going to my PowerPoint and taking it out.
Mm-hmm.
Okay.
Try that now.
Hold on a second.
Thanks, everybody, for bearing with us. Technical difficulties.
Technical difficulties here. Let's see how I do that. Let's see.
All right, I just reopen it, and you should be good to go to your next slide now if you want to catch back up to slide 13.
Okay. Oops.
We can see you at the beginning of your slides now if you want to.
That's good. Technical difficulties. Let's see what we can do here. My PowerPoint.
There you go. You're going through now.
Okay, here we go. We're back in. Back good shape.
We are.
All right. Thank you for staying with me on this. Okay. Mistake number 14, not having all the founders sign a founders agreement. Not having founders agreements it's like having a bunch of 9-year-olds playing a game with no rules. You've got to have agreements up front. Who's going to be on the board, what position each founder will hold. You need to avoid misunderstandings. We like to see in bylaws or in a separate agreement rights of first refusal with respect to the sale of any shares by a founder. You don't want someone you've been in business with to sell their shares to a stranger. So you want the company to be able to get them back. You might have veto rights with regard to certain extraordinary company actions like selling the company or borrowing in excess of a certain amount. Majority typically controls, and people may have a different deal. If a majority wants to sell the company and you have one of the founders has a little bit of an interest or you've given some stock to somebody, you want the ability to drag that minority person along with you and not have them hold it up. Somebody wants to buy the company, you want to buy the whole thing. So you have to be able to drag them along. They call that drag along rights. And by the same token, if you're a small owner in a company, you want to be able to tag along. You don't want to be left behind and have the majority of the stock sold to somebody and you're sitting there with your stock and you may never get anything out of it. There's no obligation on the part of any company to pay dividends. And a company that until they start making money, they're not going to be paying dividends. Okay. There's a whole list. When you read my slides, you'll see this. There are. I put a case there on the slide because I thought it was an interesting case. A professor named Robert. What was his name? Morley. Robert Morley actually invented the square device, and way before Jack Dorsey had it. And Jack Dorsey heard about it and basically copied the thing. They had a big dispute. Professor was given a little bit of money and told to go on, but there's a big lawsuit about it, and this guy actually, it wasn't Jack Dorsey. Agreements matter. Bill Gates, whose father did an amazing job for him. And I think the documents are available, but it really set him up in a way that some entrepreneurs are not set up. And he obviously has done well. Think about agreements. All right. 15. Not considering issues relating to founders' prior employment. You got to look, when you bring people into your company, you got to look at their agreements with their previous employers to see if there are any provisions that might inhibit the new venture. You focus on things like confidentiality and non-competes, prohibitions on soliciting customers, vendors, and employees. You got to ask if they're subject to any invention and IP assignment agreements. If they're coming into your company, it's because they have some expertise. But if they've already assigned all their ideas relating to the business to a previous employer, your company is going to get sued by the previous employer. So you've got to be very careful about that. If the person you're bringing into the company has developed IP while moonlighting, they did it on their own time, there can still be problems. If someone's working for a company, particularly if she's a key employee, he or she is a key employee, that person cannot operate a competing business. And that person just incorporating can spark a lawsuit from the current employer if it's done while that person is employed. You're supposed to go to your employer and either resign or tell the current employer that, this is what I'm doing and so on. You cannot misrepresent what you're doing. Even if you leave somebody and start up the business, if there's something called the inevitable disclosure doctrine. If someone's been exposed to trade secrets, okay, that's a special term. Somebody's exposed to trade secrets at their job, and then they leave to go work for somebody else. And the responsibilities are pretty much similar to the old ones. There are courts that say, hey, it's inevitable that you're going to use the trade secrets from the previous job. So you think you're just moving on to another position. I mean, you have certain expertise. You use it in for one company. How are you going to use it for? Well, don't even think about using the trade secrets of the old company. And if you don't think you are doing so overtly, think twice, because you may be using those concepts. Very, very tricky area. Okay, 16. This is the question that came up before. Issuing founder stock without vesting. Without vesting, a founder who quits gets to walk away with all his stock. That's the rule. Does that sound fair? What the company needs is the right to take it back at the price the founder paid for it. Number of shares subject to the repurchase right would decline over time, in which what we call a vesting schedule. Vesting restrictions ensure that founders stay committed, and if the schedule is reasonable, it's helpful with future investors who may just keep it in place rather than asking for their own. Typical vesting schedule is 4 years, 25% after 1 year, and we call that cliff vesting. All the stock comes back if the founder leaves within a year, and then 25% each year on a monthly basis after that. If people have been working together before they incorporated, you may have 3 years monthly. There's all kinds of different ways of doing that. The vesting periods have actually shortened over the last few years because just a matter of a custom. But it's always a big discussion, and a lot of founders don't like that. They want their stock, but it's just not fair. Okay, 17, not filing 83B elections. So, what in the world does that mean? 83B. So don't get too nervous. Yes, it's a tax provision, but here's what it is: you file this election, and it enables the founders whose stock is subject to vesting to pay a nominal tax on the nominal value of the restricted stock that they're given when the stock is granted to them, rather than paying enormous taxes on the value of stock when it vests at a later date. Okay, so what's that mean? What it means is that, and let me give you a great example. You start working on your company, and you have an equity incentive plan that allows you to grant restricted stock to advisors. Somebody comes along and says, hey, I'll raise money for you, but I want to be on a board of advisors. I want to give advice along the way, and I want a little stock for that. And the company doesn't have any value. You grant restricted stock to the advisor. He buys it at 0.0001 cents per share. 0.001 cents. Okay, fraction of a penny. And you give him, and you give him 0.5% of the company. Great. His stock vests because you want to make sure the advisor actually does something for you. If he files a 83B election, he pays tax on the value of the stock that he was given, a fraction of a penny per share, 0.0001 cent per share. If he doesn't file that, and it is the shareholder's responsibility, when the stock vests, so let's say you go out a year before any of it vests. In a year, if the value of that stock is $100,000 that he owns, if he hasn't filed the election, he has to pay tax on it. Yikes. That's crazy. So you got to make sure you're vested. Forms are readily available. It's file it with the IRS, you get a copy back. It's very easy to do it. You just can't forget to do it within 30 days of when the stock is given out. And if you do, and there's no repairing the mistake if you screw it up. Well, I shouldn't say that. Because we do some things by taking vesting off and putting it back on. There's some games that we can play to mitigate the probability of it.
Hey, Jack.
Yes.
It looks like we've got a question in the chat, and also we've only got about 4 or 5 minutes left in the session. So FYI.
Okay, I will whiz through these other quickly. Question for citizens and non-citizens: if you're paying U.S. taxes, you need to pay attention to this. If you're not, then you don't. All right, we're gonna have to go fast. Get an equity incentive plan set up so you can give stock to people that help you out, and put vesting on it. Like I said. Mistake 19, not having employment agreements. Same thing as what we said for founders. Okay, it's the same ideas. Number 20. This is a very, very interesting one here. If you've got to ensure that outside developers are subject to agreements as well. I call this the Winklevoss Mark Zuckerberg problem, and comes up all the time. Had Mark Zuckerberg and actually signed an Inventions assignment agreement with the Winklevoss twins, there probably wouldn't be a Facebook, or if there was, it'd be the Winklevoss twins running it and not Mark. Now, you may have seen that movie, I think The Social Contract. I forget what the name of it. They got into litigation over it, and the Winklevoss twins got paid a lot of money to settle the thing. But they had a good client. It was a great client. And of course, they've gone on into Bitcoin and to do other things and have done very well. Mistake 21, agreeing to be personally liable. Just don't do it. You just say no. You have some lawyers and inexperienced startup lawyers and who want you to stand behind your representations and warranties, for example, that you give to investors by being personally liable for them. Don't agree to it. If an angel is pushing the issue, wants you to be liable, personally liable for if they're doing a convertible note, loaning money to the company that will convert, or if they're asking you just personally guarantee the reps and warranties, don't do it. If they're pushing on it, then it's time to find a new angel. Okay. Question about it was the social network. Someone reminded me. Will an NDA suffice to cover confidential information? An invention it covers confidential information, but you've got to make sure that it wouldn't be an NDA. It would be an invention and IP assignment agreement that you need. That was a question. Okay. Mistake 22, and we're getting right to the end here. Thinking that legal issues can be dealt with later. There's a tendency for some company founders to think, hey, when I get my funding and I'm up and running, then I'll hire the lawyer. Right now, I'm working on my business plan and raising money. Very short-sighted. A lot of the points we discussed today are problems that you can't fix later. That's why I said dead on arrival, mistakes that will kill your startup. You can't fix them. So does that mean founders should devote all their time and effort and money to the legal issues? No, but there's a balance. And it costs a whole lot less to do things right at the beginning than to try to sort it out later on. Lawyers wear a lot of hats, and I encourage everybody to use the lawyer. You got to negotiate with the lawyer. It's good to get fixed fees from them when you can. If you do hourly fees, put a cap on them, make them, tell you what they think the fee is going to be. But you've got to really pay attention to that and use them for what they can do for you. Start doing a startup is like launching rockets, I think. I like this quote. If you're a tenth of a degree off at launch, you may be 1,000 miles off downrange. So the answer is pay attention to what's going on when you get going, and you'll be a lot better off later on. I will be sharing the presentation. I think that there are, here's my contact info. Feel free to reach out to me. And if you want to even set up a time to talk, I'm happy to talk about any of these issues in more detail. We talk about them at our Boomtown accelerators. We now have a new sports tech accelerator with Comcast, NBC, Universal there in Atlanta, and I look forward to going further with you. We'll make sure everybody gets these slides and my notes from them to go. Allie, anything else we need to discuss?
Nope.
There you go.
You were almost right on time, and I so appreciate it. Thank you so much, Jack.
Okay. Thanks, everybody.
Okay. Please feel free to reach out to Jack, as you saw, and then these recordings of this will be available after the event on the Techstars site. We are going to take a short break on this track, and then I believe Invesco is going to be presenting why diversity and inclusion are important when building a company, starting at 11:45. Thank you again, Jack, for joining us. We really appreciate it. And we will see everybody at the 11:45 session.
See you then. Take care. Bye-bye.